Hello and welcome back to the another episode of Daily News Quiz Analysis for IAS Prelims 2025. It is 4th January today, and in this video we are going to solve different types of questions which are very much relevant for your preparation. Before we'll start solving these questions, as usual, I would like to give the brief introduction about the video so that if you are new to this channel, you will get more connected with it. And if you are the regular visitor of our channel, I would like to recommend you guys to fast forward few minutes so that you will directly jump to the discussion part. Coming back to the introduction part, in this video we will try to discuss various types of questions. And if we break these questions into subsets or into different parts, they would definitely come under three headings. In the first part of our discussion, it would contain questions with respect to the current affairs. What it will do, what we are going to do here. We are going to take up the most important articles from the newspapers. We are going to break them down into the simplest language possible. And we are going to derive the basic prelims based questions which can be formed from those particular articles which are relevant for your preparation, so that it will give the idea how and what should be your approach towards towards your preparation, what should be your approach towards these news articles, which part of the news article is important for your preparation, and also it will give the idea how the UPSC faculty, how the UPSC examiner can frame a question from that particular article. So this is what we are going to do in the first part of our discussion. After solving questions with respect to the current affairs, we will shift out of our discussion where we will take up the questions static part, from the static topics. You know, every day we try to discuss a static topic here, and we had started with Indian polity. Right now we are discussing the fundamental duties, and today we are going to discuss a small article from fundamental duties, and we will try to frame a prelims based question from that particular article, and we will try to give the idea how the UPSC examiner can ask you a question in your prelims exam based on that particular article. And we will give the idea, even though the article may seem small to you, it may seem very much discreet to you, but still UPSC can surprise you by asking questions separately on those small particular articles. So this is what we are going to do in the another part of our discussion. After solving questions with respect to the current affairs and static topics, we will shift our approach towards the law, where we will solve questions directly from the previous year question book. What we will do in this part, we will take up some previous year questions. We'll take up few previous year questions. We'll try to break them down into the simplest language. We'll try to find out the vocabulary which the UPSC uses in the exam. We'll try to find out the ways UPSC will try to deceive the aspirants. We'll try to find out the ways and methods by which we can still solve those questions if we don't have the proper knowledge. We will try to find out how we can implement that knowledge in the upcoming exam. So this is in a nutshell what we are going to do in this video. Now, before we'll start solving these questions, I would like to recommend you one thing which I believe if you will follow, it will help you immensely in clearing your exam. That is, we are doing this we are uploading this video since 6 months now, and we had discussed various types of topics here, various types of concepts here, various types of questions here. And I am requesting you guys every day that please note down these questions. If you will note down these questions, it will help you in a very best way possible. You will have your own question bank before the exam. When the month of May approaches, when it is the month of May and you are left with few days, at that time the anxiety level will increase. You would want to revise everything, you would want to go through everything, but the time does not permit you. So you would want to give a last time revision to your syllabus, but time does not permit you. But if you have these questions with you at that time, you just have to revise these questions. These questions would definitely connect you with the current affairs. It will connect you with the static part. It will connect you, it will give you the previous year question analysis, and it will directly boost your confidence before entering the exam hall. And also, as our sources are same as the sources used by the UPSC examiner, maybe many questions can coincide. Leave the questions, at least the concepts would definitely coincide, and if you will have the last look at the concepts, it will give you the higher edge in clearing the exam. So that's what I request you guys, please note down these questions, develop your own question bank, and you know prepare for the best. And I hope when you will have these questions, you would revise them. It will definitely boost your confidence. Now, with this, I would like to request you guys, please do subscribe the channel, share it with your friends so that they may also get benefited from this initiative, and also do write in the comments what else should we bring for you so that we can help you in every way possible. Now with this, let's start with the first question which we had brought today. Today's first question which we have to discuss today is with respect to the United Nations Commission on International Trade Law, which is abbreviated as UNCITRAL. You know, you may ask me a question here, sir, why we had brought this question here? What was the reason why we are discussing this United Nations Commission on International Trade Law? Why we are taking this here? The reason to this is the answer to this question of yours is in today's newspaper, as it talked about today's newspaper talked about the cross-border insolvency and legal reforms, the cross-border insolvency which happens and the legal reforms which India should go for. You know, if you don't have this cross-border insolvency issues sorted out well in any particular country, then it will hit the investments in that particular country. For example, if we look at our country, we had not properly explained these issues in our laws. We don't have the proper explanation of cross-border insolvency, and there are chances that the investments in our country can get hit because of that. You know why we are discussing this? Let's dig deep into it. Let's try to understand the issue in a proper way possible. Let's try to understand the issue of insolvency and bankruptcy code. You know, it was 2016 when it was introduced. Now, let me explain how it works. Suppose there is a company A. There is a company A with this article. So I hope you will show some patience here. Suppose there is a company A. It has borrowed from any lender L. It has borrowed from any market in India itself right now, and the company A is not able to pay back the loan. It has taken the loan from L and it's not able to pay back the loan, and time has passed. The agreement, the time given in the agreement, it is gone way beyond that. Now what they can do, what here, how can this lender get this money back, or how can this company A pay back to the lender L? So what they will do, they will either lender L or the company A, they will go to the National Company Law Tribunal. They will go to the National Company Law Tribunal. So this National Company Law Tribunal, it will take the insolvency resolution and it will conduct this insolvency resolution. It will take it up, and the maximum time period within which it should sort this issue, within which it should solve this issue, is given 330 days. So here you can ask me a question, sir, why 330 days? Why within 330 days this issue should be sorted out? But trust me, it takes way more than 330 days. But at least on the paper, it should be sorted out in 330 days. What this NCLT, what this National Company Law Tribunal will do, it will sell the assets of this company. It will, auction the assets of this company, and by the auction, it will raise the money, and that money will be paid to the lender. So this is how it will work. Why the time limit is given to 330 days? Because if for example any company who had filed the bankruptcy code, who had filed the bankruptcy, the market knows that the value of that company decreases by time. The value of that company goes down by the time. For example, right now, if that company is able to produce 100 rupees, after 1 year, that if that company right now is able to generate 100 rupees through its assets, after 1 year the value of its assets would decrease to 50. So there is a drastic decrease of the value of the assets of that particular company, and if the auctioning will take much than 330 days, the value won't be generated that much, and the money which the lender will receive will be very much small. So this is the issue. That is why it is recommended that it should be sorted out before 330 days. Now this is the story of a company who had got loan, from the domestic market, from the companies who are working in India. Now suppose here is a company. Now here is a company, namely company B. She had got loan from company L and company M. Suppose She had got loan from company L and company M. This company M, she is operating in India, Indian market. Company L, she is operating elsewhere in different country. So here comes the issue. When this company B will file for the bankruptcy, or company M will go to the national company's NLCT, it will go to NCLT. They will ask for the auctioning of the assets of the company. At the same time, this company L, which is operating in some different country, which is the company of, which is the market of some different country, they will file the same case with respect to company B, which had borrowed the money from this company also in their own particular country. When here I will explain you, two cases would be filed at the same time in India, one in India and another in different country. So what will happen at that time? Say a company who has borrowed from different markets, a company who has borrowed from India, a company who has borrowed from different markets in different parts of the world. Because of the globalization, the more trade, we had got more connected with the world, and it has borrowed money from different markets. And at the same time, those companies, those lenders are filing this bankruptcy. Those lenders are going to their filing the same cases which this company, which the lender in India has filed in India with respect to Indian laws. Now, what will happen? At that time, there would be the conflict of interests. So, to sort out this issue, the United Nations had came up with the United Nations Commission on International Trade Laws. To this commission, it was with respect to this commission, it was established in 1966, and its secretariat is in Vienna. So it has, this has been this United Nations Commission on International Trade Law. It solves these issues when such cross-border insolvency happens. But there is a problem with this too. The problem is not all the countries had agreed to it. There are only 60 countries which had agreed to it, and if we'll take the example, USA has agreed to it, Russia has not agreed to it. Now suppose there are countries, the company, it had brought from the market, from those market, for example, the company has brought money from the Russian company, Russian market, as well as from the US market. So there definitely would come up there would definitely be an issue. So with respect to that, the India has IBC, India has Insolvency and Bankruptcy Code 2016. Under it, we have we have different sections, which is section 234 and 235. These sections, they talk about, promotion. They talk about the promotion of cross-border insolvency, but these sections also do not provide any comprehensive solution. Both countries, under these sections, what will happen? The both countries which are involved, they will sign the agreement. How proceedings will be done, they will decide that. Which country will be, prioritized, that will be decided. So India has to notify this. India has not notified it. India has to notify that too in their laws. So this is the nearest we had reached to solve these issues. This is the nearest, the IBC section 234 and 235. This is the nearest we had reached right now to solving the issues of cross-border insolvency, but it is not also comprehensive. It is not complete. So with this regard, the author in the news article today, he talks about that if we don't have these laws very well mentioned, if we don't have the particular laws with respect to the cross-border insolvencies, it will hinder the investment in India, because the companies would fear that if such scenarios will arise, what will happen to their money? So it will definitely hinder the investment in India. And the author recommends government that they should come up with the laws which would solve these issues. That government should frame the laws, they should frame the rules which would solve these issues of the cross-border lending. So this is in a nutshell about the news article. I hope you had understood it. I hope I was very much clear in explaining that, and that is why we had brought this question. So let us understand through this question more about United Nations Commission on International Trade Law. Here the question says, with reference to the United Nations Commission on International Trade Law, consider the following statement. First statement, UNCITRAL, which is United Nations Commission on International Trade Law, is the core legal body of the United Nations. United Nations system in the field of international trade law. 100% correct, nothing wrong with the statement. Second statement, its mandate is to modernize and harmonize rules on international business, including formulating conventions, model laws, and rules that are acceptable worldwide. 100% correct, nothing wrong with this statement. Third statement, the UNCITRAL, which is the United Nations Commission on International Trade Laws, model law on cross-border insolvency, has been adopted by India with certain modifications to make it suitable to the Indian context. India has not yet adopted it, but we have IBC section 234 and 235, which are very much near to it. So in somehow we can say it is correct. India has adopted few of such issues, but it has not properly taken this. So if it is half correct and half incorrect, so we'll mark it incorrect. So with respect to this question, the correct statements are statement 1 and statement 2. Right now we don't have any proper explanation to it. We don't have the proper, as we discussed it in the discussion, as we discussed it in the context part also, we don't have the proper laws, as the author raises these concerns with respect to the cross-border insolvency. So there are issues, even though India has adopted to somehow, but we had not fully adopted it. As the third statement says, the model law on cross-border insolvency has been adopted by India with certain modifications to make it suitable to the Indian context. Even though, yeah, as model law we had adopted. Sorry, this statement is correct because we have IBC section 23, 234 and 235. So with respect to this question, all the three statements are correct. Now with this, we'll move to the another topic and solve the question there. With respect to this question, I hope you had understood the context. You had understood about the United Nations Commission on International Trade Law. It was introduced in 1966. The secretariat is in Vienna. We discussed about what is its function. We discussed what is the issues arising because of the insolvency, cross-border insolvency issues. So with this, let's move to the another topic, another slide, and solve the different question there. Here the question is about, with reference to the Digital Personal Data Protection Act of 2023, consider the following statement. Why we had brought up this question? Because today, this Digital Personal Data Protection Act of 2023, it was introduced, as it is mentioned there, this act was introduced in 2023, and today rules were framed. The government framed the rules. The IT ministry yesterday, they had notified the rules with respect to Digital Personal Data Protection Act of 2023. So let's dig deep into the rules. What does they say? Let's try to understand more about it, then we will solve the question here. First of all, it talks about the data protection, personal data protection of the people in our country. So first of all, companies, few points which you should know, which I will believe you should copy these points. First of all, the companies which will collect information will be referred as fiduciaries. Those companies, for example, there is company Google Pay is there, YouTube is there, they will collect your information. That information, those companies would be called fiduciaries. When the second thing in this, they would be called fiduciaries. Second thing which you should know about these rules, that when they collect the data, they will have to seek the consent of the user. They cannot collect data on its own. They will definitely have to seek the consent of the user. They will have to see, for example, if Google Pay wants to collect your data, they will have to seek the consent of the concept of you before collecting that data. And third point in this, which was notified, for what purpose they are collecting this data, they have to give the precise reason for that, for what purpose they are collecting this data. Fourth, first thing, the collector, those companies who collect your data, they are called fiduciaries. Second, they have to seek the consent before collecting the data. And third, they have to give the reason for which purpose they are collecting data. Then the fourth question, which was addressed in the act itself, that whether they can store this data outside India. And with respect to the act, the answer to this, they can store data outside India. They can store data outside India, but in the rules, the government has proposed domestic and localized requirements. So there are some issues which are not yet clear. And the fifth important point under this act, under these rules was, which the article mentioned, that the companies which are collecting these data, they should, they should take measures to protect it. There should be no data leaks. They should take extreme measures to protect it. So these are few points which were notified. First, the fiduciaries, those who collect data, seek the approval, seek the consent. Third, for give the reason why they are taking the data. Fourth, you know fourth was, they should, whether they can store the data outside India. Answer to this was yes, but in the rules, in the act, the answer was yes, but in the rules there, the government has proposed domestic and localized requirements. Then the fifth, the company will have to implement the measures to protect the data. The companies which are collecting the data, they have to implement the measures to protect the data. So these were the things which were mentioned. And also, the government, under this act, the government will set up data protection board, which will, which will take care of this. These are the few things which are notified under the Digital Personal Data Protection Act of 2023. And one more thing about that, there would be the classification of companies which will collect your data, and one classification would be the significant data fiduciaries. They will have, those companies which will have the amount of data which they will have, those companies will be called significant data fiduciaries. So these are the issues. These are few rules which were notified. Now with this, let's try to solve this question and get more idea about it, get more idea about the Digital Personal Data Protection Act of 2023. Let's see what does the question say. With reference to the Digital Personal Data Protection Act of 2023, consider the following statements. First statement: the act mandates the establishment of Data Protection Board of India to address grievances related to personal data processing. Yes, it will, the government will set up this. Second, it grants explicit consent from the individual as a prerequisite for processing sensitive personal data, which includes biometric data. 100% correct. Explicit consent from the individual is required. That is the prerequisite for processing sensitive personal data. 100% correct. Nothing wrong with the statement 2. Third statement: the act applies only to entities operating within the India. Totally incorrect. It applies to both within India or outside India. So third statement is incorrect. Fourth statement: under the provisions of Act, personal data can be processed without consent in certain cases, such as compliance with legal obligations or public interest. 100% correct. Nothing wrong with this statement too. And one more thing which was notified in today's rule is that if the data has to be deleted, notice has to be given to the user. They have to give the, if the companies are going to delete any data, they will have to give the notice to the user. So coming back to this question, as the third statement is incorrect, we can eliminate option A, we can eliminate option B, and as the third statement, we can eliminate option B, and we can also eliminate option D. So we are left with option C only, which is the correct answer to this question. So with respect to this question, I hope you had understood the Digital Personal Data Protection Act of 2023. Why we had discussed this? Because its rules were notified by the IT Ministry yesterday. And what were the rules? Few we had discussed here, few important rules. The collector of the data would be called data fiduciaries. They will have to seek the consent of the user. Third, they will have to give the reason why they are collecting this data. Fourth, whether they can use this outside country, whether they can store the data outside country. There are some issues with respect to that. Fifth, you know uh, how they have to, the government will go for the Data Protection Board of India. They will have to notify if they are going to delete this information. So these are few rules which we discussed in detail in this discussion. So with this, let's move to the another question and try to solve that. Here the question is with respect to the Bhopal gas tragedy. One of world's worst industrial disaster was primarily caused by leakage of which of the following gases. Why we are discussing this? Recently, few days back, we discussed an article about that, how the MP government had decided to, to get rid of the waste because of the Gopal gas tragedy. And tragedy. And in this regard, the Central Pollution Control Board and the State Pollution Control Board with Madhya Pradesh government, they took the steps and they are going to dispose it. And where they are going to dispose it is in Pitampur. And with respect that, the protest has erupted in Pitampur over the arrival of Bhopal waste. You know what they are going to do? First, they will either burn it there, either burn it, or they will bury it under the soil. They will bury it, burn or bury. So here the issues which the population in the Pitampur raise is that once they are going to burn it, it will definitely release the toxic gas, and it will impact the population there, to which the government says they will take the necessary necessary things which are required here to to suppress that, to protect that. So this won't be the issue according to the government, but according to the people in the Pitampur, this is the major issue. Then another thing, if they will bury this as there are toxic substances, they will leak to the groundwater, and it will definitely impact the groundwater. To this also the government says will take the necessary steps which will which will hinder this issue which they are talking about. But there the people in the Pitampur did not they are not accepting these answers from the government right now. There should be the proper discussion between the people. The government should try their best to explain them how they are going to dispose this waste. So this is the context of this question. Now why this is the context of this question. Now let's try to solve this question what has been asked here. The question says the Bhopal gas tragedy, one of the world's worst industrial disaster, was primarily caused by the leakage of which of the following gases? It is definitely methyl isocyanate. So the correct option to this is option B. Why we discussed this question? Because of the protest erupts in Pitampur, as the Bhopal waste is going to be disposed there. So with this, let's move to the another question and try to solve that. Here the question is with respect to the UN Convention on the Law of Non-Navigational Uses of International Water Course in 1997 is primarily based on the principle of what? Why we are discussing this question? Because we had discussed the year long, or we can say Brahmaputra water project, Brahmaputra electricity project, hydroelectric project from which the China has invested 137 billion dollars, and it has raised concerns with respect to India and Bangladesh, as they believe that India and Bangladesh, especially India, believes that China can misuse it against them, as they are the upper riparian state. They have the control over the water, and if they will control the water, they can weaponize this water. Either they will store the water in the dams and release it suddenly, and it will cause floods in our country, in Indian states, or they will totally restrict it, and it will cause drought in the Indian states. So India has various issues with it. So with respect to this, we need to understand the UN Convention on the Law of Non-Navigational Uses of International Water Courses. As here we should know that neither India, neither India nor China is part of it. But here the author says that India should raise the statements, raise the concerns here, and India should highlight this issue, and India should use this convention. So let's try to understand what this convention is about. What does it say? Let's try to solve this question, and then we will come back to the context. Here the question says the UN Convention on the Law of Non-Navigational Uses of International Water Courses 1997 is primarily based on the principle of absolute sovereignty of riparian states over the portion of the water course within their territory. Totally incorrect. Prior appropriation granting water rights to the states that first uses the water. Nothing correct with this statement also. Equitable and reasonable utilization and participation of all basin states. 100% correct. This is the major principle this UN Convention on the Law of Non-Navigational Uses of International Water Courses is about. It talks about the equitable and reasonable utilization and participation of all basin states. Under this under this convention, the upper riparian states will not be allowed to apply policies which can impact lower riparian states. So the upper riparian state here is China. They cannot, you know here we are not the part of this, but what does it say? That the China, the upper riparian state, cannot make the policies, implement the policies with respect to the water which can impact the lower riparian states. So here the author says, as China has invested 137 billion on the Brahmaputra project, on the Brahmaputra hydroelectric project. So it is the time that India should highlight this issue. India should highlight it before the world, that how China can weaponize water against India in the extreme conditions. Even though China is saying that they are not going to weaponize it, it would be the runoff project, but still we cannot trust China. So here what becomes important for us is the United Nations Convention on the Law of Non-Navigational Uses of International Water Courses. It becomes important for us. We need to know about it, and it is about equitable and reasonable utilization and participation of all basin states. It talks about that upper riparian states will not be allowed to apply policies which can impact the lower riparian states. So this is what you need to know about this article. Now with this, let's move to the another question. Last question from current affairs today. Here the question, it is about the equal opportunity centers. The question says, consider the following statements with regard to equal opportunity centers in India, in Indian universities. Why we had brought this question? Because the Supreme Court of India has asked UGC, Supreme Court, SC, Supreme Court has asked UGC, it has asked UGC and to submit information regarding the practice of universities for setting up equal opportunity centers, that the UGC should submit the information regarding the practice of universities for setting up this equal opportunity centers. In our country, as we are divided by the caste from the centuries itself, we often hear in the news is that only that particular person died because he belonged to certain caste and he was bullied in the colleges, in the universities. So to overcome this issue, the UGC, it has asked the universities to go for the equal opportunity centers. And with respect to this, the what its approach is, what this equal opportunity center is going to do, that we will understand through this question. So with respect to this, the Supreme Court has now asked the UGC to submit information regarding the practice of universities for setting up equal opportunity centers. So let's discuss this question, let's solve this question, let's understand it and get more idea about it. First statement about it, the establishment of equal opportunity centers in universities is mandated by the University Grants Commission to promote social justice for students from marginalized communities. 100% correct. It can be scheduled caste, it can be scheduled tribe, it can be other backward classes, it can be minorities, it can be women. So it includes everybody, the marginalized community. It includes every marginalized community. So with respect to this question, the correct statement, first statement is correct. Second statement, the equal opportunity of centers focus exclusively on the welfare of the students. Here, look at the statement, exclusively on the welfare of the students from scheduled castes, scheduled tribes, and other backward classes. Totally incorrect. It does not only include these classes, it also includes other marginal communities like women as well as other minorities. So, with respect to this question, the second statement is incorrect. Third statement, the primary role of the EOCs includes monitoring the implementation of reservation in higher educational institutions and providing a platform for grievance redressal. 100% correct. It will monitor whether the reservation is given in the higher education institutions, and it will provide a platform for grievance redressal. The bullying which they face, which these people face in the colleges, it would be sorted out through this through this through this platform. So this statement is also correct. Fourth statement, EOCs in universities are also responsible for organizing awareness programs about diversity and inclusion within the academic community. 100% correct. It is also responsible for organizing these awareness programs about diversity and inclusion within the academic communities. So this is what the equal opportunity centers is about, and why we had discussed this, because the Supreme Court has asked UGC about the information and to submit the information regarding the practice of universities for setting up equal opportunity centers. So with this, the correct answer to this question is, we can eliminate option 2 here. We can eliminate option 2 here. We are left with 1 3 and 4 and 1 3. The correct option would be option C. So with this, we complete today's discussion with the current affairs. I hope I was able to explain every topic properly. We had discussed, I was able to discuss these questions properly. I hope you are not left with any confusion. If there is any, please do write in the comments. I will definitely try to clear that. Now with this, let's move to the another part of our discussion where we will solve a static based question. Right now, as you know, we are discussing Indian polity, and in Indian polity, we are discussing the fundamental duties. And fundamental duties are in Article 51 A. They are contained in Article 51A. As we know about fundamental duties, they were not the earlier, they were not the part of the Indian Constitution. They were added through the 42nd Constitutional Amendment Act. It was recommended by the Sovereignty Committee, which was supposed to review the constitution, and they recommended that Indian constitution should have the fundamental duty, and it was introduced in the 42nd Constitutional Amendment Act. And also we got inspired from USSR, where from we got it. Now today we are discussing the fundamental duties. We had discussed fundamental duty 51A, clause B, clause C, clause D. Now today we have to discuss clause E. So let us see what does this talk about. Here the here the question says Article 51A clause E of the Indian Constitution, a fundamental duty relates to safeguarding public property. No, totally incorrect. Protecting and improving the natural environment, totally incorrect. Third statement, promoting harmony and the spirit of common brotherhood among all the people of India, transcending religious, linguistic and regional or sectional diversities, 100% correct. This is what the Article 51A subsection 51A clause C say. And also it says to renounce practices derogatory to the dignity of the woman. So this is exactly what the Article 51A says. It talks about promoting harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities, and also to renounce practices derogatory to the dignity of women. So with respect to this question, the correct statement is option C. It is about promoting harmony and the spirit of common brotherhood. So with this, I hope you had understood it. There is nothing left. I hope there is no confusion left. Now with this, let's move to the last part of our discussion, where we will solve the previous year question and we will conclude our discussion there. Here, today's question, as we know, we are right now discussing the physical geography. Questions asked in physical geography. We had already discussed ancient history. We had discussed questions related to the medieval. We had discussed questions related to modern. We had discussed every question related to the freedom struggle. Now, after discussing the history part, we had reached to geography, and today we are discussing the physical geography. And this question was approximately asked in 1998. If you had followed me from last few days at least, you would definitely know that we had discussed a question. To be more precise, a day before yesterday, we discussed a question with respect to asteroids, the asteroid belt. So you can see how they have the habit of repeating the question. Let's see what does the question here say. Consider the following statements regarding asteroids. First statement, asteroids are rocky orbits of varying size orbiting the sun. Are the rocky debris of varying size orbiting the sun. 100% correct, nothing wrong with this statement. They orbit the sun. They are the rocky debris which orbit the sun. Second, most of the asteroids are small, but some have diameters as large as 100 kilometers. 100% correct, nothing wrong with this statement. Third statement, the orbit of asteroid lies between the orbit of Jupiter and Saturn. If you will remember, we discussed this in our I will be more precise, a day before yesterday we discussed this question. Where does this orbit of asteroid lies? It does not lie between the orbit of Jupiter and Saturn, but it lies between the orbit of Jupiter and Mars. So if it is Sun, it is Mercury, it is Venus, it is Earth, it is Mars, it is Jupiter. This is the orbit of these asteroids. Here they lie. So with respect to this question, the third statement is incorrect. And here we will understand the trick. If the third statement is incorrect, what we can do? We know, for example, if you would have read about, if you would have gone through, if the students, when they were studying that time, if they would have gone through the previous year question paper, they would definitely understand that this statement is incorrect. Now, Suppose they don't know about the first two statements, what they will do? They will know this statement is incorrect, third statement is incorrect, because they had seen in the previous year question paper that it is not between the Jupiter and Saturn, but it is between the Jupiter and Mars. Now what they will do here? They will definitely eliminate option A because it contains option C, or that is option 3. They will eliminate option B also because it contains option C in it also, and they will also eliminate option D because it contains option 3 in it also. So now they are only left with 1 and 2, and that is the correct answer. That is 100% the correct answer. So this is the method which you can use if you don't have the proper knowledge. This shows how much important it is for us to go through the previous year question papers. Now with this, I would like to say thank you very much if you had stayed with me. Thank you very much for staying with me. This initiative is for you. Please do write in the comments what do you feel about it. We try our best to clear every concept here, but we are humans, we may tend to make mistakes. Please do write in the comments where we had lacked. We will try to cover that. With this, I would like to say thank you to you guys. Have a nice day. Have a nice year.